My Lords, my Lady, before the lunch adjournment, I was just touching on the point that despite Lord Nicholl's caution in Ramanup that expressions such as punitive or exemplary damages were best avoided, there is in fact some authority to the effect that an additional award would rarely be justified if an award of exemplary damages would not be warranted. And I have just taken you to the case of Lumba. Since this is not an argument that I rely on, but I thought it right that the board be aware of, can I just give you the reference to the one Caribbean case that in which exactly the same thing was said by, again, Lord Kerr. It's the case of Welsh and the Attorney General, and it's at 3606. I won't take you to it, but it was a case of a young man of 17 who was convicted of murder and sentenced to be detained during Her Majesty's pleasure, and an issue as to his entitlement to damages arose. And the relevant paragraph is paragraph 20, where Lord Kerr referred to Lumba and repeated exactly what he had said in Lumba. My Lords, as I say, I thought it right that your Lordships be aware of that. I have accepted, I hope, clearly, that there could be a case where there were not the sort of factors required for an award of exemplary damages, where an additional award might nevertheless be justified, but made it clear that I do not accept, as the Court of Appeal did not, that in all the circumstances such an award was required in this case. Now, the Court of Appeal, as I have submitted, held that compensatory damages were sufficient and that the judge therefore erred in awarding an additional amount of $1 million. Now, whatever the board may think of their reasoning in that regard, and I have sought to suggest that what they were talking about when they referred to institutional inertia was institutional inertia on the facts of this case, but whatever the board may think of their reasoning, I submit that they were right to conclude that the judge erred in making an additional award, and I hope I accepted the second time it was put to me by Lord Burrows the way in which he encapsulated our submission in that regard. Can I therefore take you to the judge's judgment at paragraph 219 in the first instance at page 411. And there the judge said, it is gleaned from the case law that the court has the jurisdiction to award two types of damages, compensatory damages and vindicatory damages. The issue of compensatory damages will first be addressed. Now, on one level, that may be a correct statement, but it's not, in fact, a strictly accurate statement, since, as I submitted at the outset of my submissions, the purpose of all constitutional damages, whether compensatory or in the form of an additional award, is to vindicate the relevant breach. That is clear, I submit, from Ramanup itself, but it's also clear from two other authorities, which I'll just take you to briefly, if I may. The first is the case...
Sorry, what's supposed to be wrong with paragraph 219? It seems obvious that that's how one's got to approach it.
No, but it could be read as the judge distinguishing between, on the one hand, compensatory damages and on the other hand, vindicatory damages. My only point is that all constitutional damages are vindicatory in nature. In other words, compensatory damages as well.
Well, I think that...
You're compensating the victim of the constitutional breach for the breach of his or her rights.
Yes.
And to that extent, the individual's rights are being vindicated. But what Ramanup seems to be talking about is that you're putting down a marker because of the severity of the breach and wishing to deter other breaches, for example, that may merit an additional vindicatory award over and above the personal vindication through compensation.
Well, I find paragraph 219 difficult to object to. There are two types of damages.
My Lord, it may be semantic, and maybe I'm reading too much into it.
Okay.
The only point I'm making is that whatever the judge was was there saying, and it may be entirely fair.
But it's the difficulty with, as my Lord Burrows was saying before the short adjournment, with comparing this with exemplary damages, is that I think compensatory damages is also a bit of a misnomer, because it's not like tortious or contractual compensatory damages, for which you have to prove loss.
Well,
we're not talking about the proof of loss and sort of these weren't, although these were compensatory damages, they weren't strictly damages for pain and suffering or something as you would have had in a tortious claim.
My lady, I accept that, but what I would say is that what the authorities, including the constitutional authorities, make clear is that you can have compensatory damages which are proved in the same way as they would be at common law in a constitutional claim. The question then is whether or not that has sufficiently vindicated the rights, and if it has not, you may well find that there is scope for a vindicatory or additional vindicatory award. Now, there's also dicta in the authorities to the effect that in a case where it's not readily possible to quantify the loss, and there have been any number of cases in the Privy Council where people have complained about authorities dragging their feet in relation to consideration of claims for promotion within the police service or some other service, for example. That particular claimant may not be able to prove in any conventional way a loss. I mean, at the very best, it might be loss of a chance, but it might not even be that. Now, that sort of case is one where the court might find it easier to award an additional award to reflect what is really general damages for something that can't be quantified. So there is scope for compensatory awards within constitutional claims.
But general damage, an award of general damages is a compensatory award.
It is a compensatory award.
And in one sense, none of these sort of damages for an assault or false imprisonment, in one sense, they can't be quantified, and that these are amounts of what's perceived to be a fair measure of the wrong. They're not economic loss in any way, or quantifiable in economic terms.
No, I mean, there one is talking about general damages, most definitely. Could I just, on this point about compensatory damages and vindication, could I just show you Merson and Cartwright, which is 3039. At paragraph 18, which is at 3048. And these principles, and those are the principles in Ramanut that have just been set out, apply in their lordship's opinion to claims for constitutional redress under the comparable positions of the Bahamian Constitution. If the case is one for an award of damages by way of constitutional redress, etc., then, dropping 4 lines, the nature of the damages awarded may be compensatory, but should always be vindicatory. And accordingly, the damages may, in an appropriate case, exceed a purely compensatory amount. The purpose of a vindicatory award is not a punitive purpose. It is not to teach the executive to misbehave. Dropping a few lines, the sum appropriate to be awarded to achieve the purpose will depend upon the nature of the particular infringement and the circumstances relating to that infringement. And then just one other case of this, Graham.
I mean, is that statement that it's not to teach not to teach the executive not to misbehave? Is that consistent with the statement in Ramanut that it's to deter?
Well,
not really.
Maybe not, my lords. I mean, on one view, there is a slightly vague concept between deterrence and punishment. I think that's the answer.
That is the line being drawn.
Yes, it is the line.
I mean, in Ramanut, they were saying it's deterrence, but it's not punishment. Yeah, it's not to teach them a lesson, as it were.
Exactly, my lord. And that's exactly what this says.
Yeah. Well, I think that's what it means.
It would be clearer if they...
Yes.
Yes. That's what, my lord, I hope that's a sufficient answer.
Yeah.
The other authority on this point is Graham, which is at 3616. My lord, Could I just take you to paragraph 16, between letters G and H. What Lord Justice Laws, sitting in the Privy Council, had just done is to refer to what I read you from Merson. And he then says, just above letter H, plainly the statement that the nature of the damages should always be vindicatory does not imply a rule that a distinct vindicatory award should be made in every case of constitutional violation. As the balance of the passage shows, it merely serves to indicate the overall purpose of any award of damages in constitutional cases. Now, my lords, whilst I do not suggest that the judge proceeded on the basis that she was required to award what she termed vindicatory damages, in other words, to make an additional award, I respectfully submit that it would seem clear from her approach, to which I will come, that she did not appreciate that compensatory damages could themselves serve a vindicatory role. And in that respect, can I ask you to look at paragraph 232 at page 416 of the bundle. This court has determined that damages calculated per diem is the appropriate...
Sorry, can you just give me the reference again?
Yes, page 416,
Thank you.
Paragraph 232, my lord.
Thank you very much.
This court has determined that damages calculated per diem is the appropriate approach in light of the aggravated features of the age of the child, the physical, mental, emotional and sexual abuse as per the judgment in Takitota. The court considered the authorities submitted by the parties and decided, and then she sets out the per diem rates. Now, there the judge alluded to the aggravated features. Could I just ask you please to, well, my lords, both generally and from her reference to Takitota, it would seem clear that what the judge was there referring to was factors such as those justifying the award of aggravated damages at common law.
Are you going to take us to Takitota?
I will. My lord, almost immediately. What she was there doing was referring to factors such as those justifying the award of aggravated damages as a component of a compensatory award at common law. Now, what the board said in Takitota about aggravated damages is at paragraph 12 of its judgment, and Takitota is at 3271, my lord. And I'll be coming back to Takitota for other purposes, but just for the moment, looking at 3277, just above little I, at the bottom of the page, in awarding compensatory damages, the court may take account of an element of aggravation. For example, in a case of unlawful detention, it may increase the award to a higher figure than it would have given simply for the deprivation of liberty, to reflect such matters as indignity and humiliation arising from the circumstances of the arrest or the conditions in which the claimant was held. The rationale for the inclusion of such an element is that the claimant would not receive sufficient compensation for the wrong sustained if the damages were restricted to a basic award. Now, it's that, I think, that the learned judge, having looked through Takitota, must have had in mind when she said what she said in the passage to which I just took you. Now, so factors justifying aggravated damages, as the board will be well aware, typically include treatment giving rise to indignity, feelings of humiliation and shame, and they're very commonly reflected in awards made at common law in this jurisdiction in claims for false imprisonment. Now, my lords, what I say about this is this, that in determining the appropriate per diem rate for the purposes of compensatory damage, the judge, therefore, characterised, as we've seen from the paragraph to which I've just taken you, the appellant's age and the physical, mental, emotional and sexual abuse he suffered as aggravating features or factors. And those factors may, of course, have given rise to feelings of humiliation or shame in the same way as is sought to be recognised by the award of aggravated damages. But inasmuch as they constituted the essential facts of the case, what happened to him, the nature of the treatment, the conditions in which he was held, they were also all factors highly relevant to two of those factors identified in Ramanoop as being triggers or potential triggers for an additional award. Namely the importance of the right, but in particular the gravity of the breach.
But isn't it coming at it from two different ways? Because the compensatory are looking to see how much harm did the individual suffer, and that can include feelings of humiliation, indignity and so forth, but it's all part of the harm that you're trying to compensate the individual for.
Yes.
And then after you've awarded that, don't you stand back and you say, well, is it sufficient in this case to have compensated the harm that the person has suffered?
Yes.
Or is what the state has done such a grave infringement of human rights and so outrageous that those rights need to be vindicated by something more than just compensating the person for what they have personally suffered?
But, my lord, in considering the circumstances, I mean, that's precisely what you do in considering the circumstances of the particular complainant's detention, what happened to them, how bad it was, how grave were the breaches. And it's those self-same factors that go to the component of aggravated damages in a claim at common law and feed into the gravity of the breaches as a factor identified in Ramanoop. So there is clear overlap here. Can I just ask you to look at paragraph... I'm sorry.
It seems to me the factors that are being referred to in 232 are factors which are relevant to a compensatory award for this particular claimant, not aggravated damages, because the effect on a child of 10, 11, 12, 13 may well be more severe than on an adult.
Well, my lord,
isn't that really what the judge... And again, the nature of the physical, mental, emotional and sexual abuse suffered by him.
My lord, I accept that up to a point, if I may say so. The point is this, that whilst as I've submitted what typically the court is looking at in a case of, or in a case where it may be appropriate to award aggravated damages, is the feelings of humiliation or shame engendered by the... No, I accept that. Engendered by the treatment. Yeah. What the judge has here done is referred to Takitota, which was talking about those feelings of indignity and humiliation, called them aggravated features, but then referred to features of the detention which are much more obviously connected with the gravity of the breach, the Ramanoop factors. So she's effectively taken factors which go to the gravity of the breach into account as aggravating features. It doesn't matter whether she's right or wrong in her label. My point is that she's taken them into account in arriving at her compensatory award. Can I just ask you to look at...
In your case, then, that the vindicatory damages were duplicative.
Duplicatory, my lady.
Don't you then get into a sort of counterintuitive conundrum, which is that the worse the conditions and the treatment that there were, the higher the compensatory damages will be. Therefore, you would say the more vindicatory they are, and so the more outrageous the treatment, the less justification there is for an additional vindicatory.
Well, my lady, I'm not sure with respect. Another way the judge could have approached this is to say, look, what happened to this young man? He was put in the wrong place. He was assaulted. He suffered injuries. I'm going to compensate him for those injuries. But then she could have looked separately at features such as his age, his mental ability, his illness, and drawn the conclusion that those additional factors justified an additional award. She didn't do it that way. What we're concerned with is deciding whether or not the award was appropriate. And my point is that there is clear duplication because of the way she has approached it. Whether she was right or wrong to approach it that way matters not.
Well,
I'm sorry.
I struggle with this so much. At the moment, I can't see in anything that she said or her approach how you can label or say something critical about what she said. She said at 219, I'm looking at compensatory damages first. She's then done that with the aggravated feature of compensatory damages, as you rightly say in paragraph 232, all compensatory damages, albeit aggravated. And then at 234, having set out what the compensatory damages are, she moves on to vindicatory damages. As my Lord Legate has said, that is now where we move away from the consequences for the individual, the harm, to other factors.
Well, my lord, but with respect, and presentationally or structurally, that's what she's done, certainly, but with respect, what Ramanoop invites the court to do in considering whether it should make an additional award is to look at, among other things, the gravity of the breach.
The gravity of the breach isn't just limited to the harm that it's caused the person.
No.
That's the point, isn't it?
My lord, it may not be, but those are very important factors. Why was this serious? It was serious because this was something that was permitted to happen to a young man with a serious illness. It was serious because of the conditions in which he was placed, those with whom he mixed, older children and so on and so forth. And those are all factors.
Well, they are, but isn't it saying that when this sort of harm is inflicted for such a long period on a vulnerable child, it's not enough?
Well,
so the judge thinks just to compensate the harm that child has suffered, one has to mark the state's utter failure to comply with its with the obligations to protect.
But my lord, there comes a point where the award
against those right infringements.
But I see the point, my lord. But there comes a point when, depending on what the judge has looked at, effectively, in arriving at a global award which takes into account all these factors, and I'm going to show you another paragraph in a moment of their judgment, there comes a point where, on any view, the severity of what happened or the wrong perpetrated by the state, wants to put it in those terms, has been sufficiently marked, and I would submit, if I will in a moment, any deterrent purpose has been served. But can I just ask?
What about public outrage, which you took into account? We're going to address that.
Well, my lord, I come back to the magnitude of the award. If the award properly reflects all these things in all their severity.
But it's not intended to reflect public outrage when you're assessing what harm the child has suffered. It just doesn't come into that at all.
No. Well, my lord, the Court of Appeal considered, rightly in my submission, that it did serve that purpose as well as the deterrent purpose, because it concluded that the vindicatory purpose had been served, and this was a very substantial award.
But they took the view that the compensation, which included taking account of the age of the child, the terrible nature of the abuse which the child suffered, etc., what was adequate vindication. That was their conclusion.
Yes, it was.
But that didn't make any allowance for the Ramanoop factors of public outrage and emphasising the importance of the right of speech.
With respect, my lord, I would say impliedly it did, because they directed themselves precisely to those factors and then concluded that the vindicatory purpose, the overall vindicatory purpose, had been served. But Muddle, can I just show you one other paragraph of the judgment? It's 229 at page 4 on the front.
I mean, 235 is worth looking at.
229.
Yes, my lord, let's look at 235 first. I'm sorry.
Because she there addresses the Ramanuk features in the context of considering vindicatory damages.
Well, she refers to them.
Well,
I'll have something to say about the lack of analysis in a moment, and also about the table. Can I come back to that in a moment, my lord? Can I just take you briefly to 229 before we go on and over 235? The court finds that the criteria for awarding compensatory damages, as set out in Ramanuk, is appropriate in this case, as it requires more than declaratory reliefs. Joshua is entitled to an award of compensatory damages for the harm done to him. That harm was detailed throughout this judgment, but it bears repeating. It includes more than just being housed at a place contrary to law from the age of 9. It also includes being placed with child offenders, being placed with adults, not receiving the proper care that it was determined he needed, the severe abuse meted out to him by other residents as well as by staff. There was sexual assault. He was burnt and beaten. There were also periods of solitary confinement and other forms of treatment appropriate for the care of patients with a mental illness, but not for a child with Prader-Willi syndrome. Now, all of those factors have been taken into account and all go, in my submission, to the gravity of the breach.
And they go to the harm suffered by the child, don't they?
Well, and the gravity of the breach, model. Of course they
Well,
go.
the gravity of the breach is the failure of the state over many years to address these shortcomings.
Well, on one view, yes, but on another view, it's the seriousness of the breach, how bad a harm was done.
Yeah.
How serious a harm. There's a difference between, I mean, the case my learned friend put in overnight, the slap by a police officer, and a serious sexual assault or a beating, for instance.
Right.
That, in my respectful submission, does go to the gravity of the breach as well as the point my leader. Now, I said I'd come back to 235. So, my lords, just before I do that, inasmuch as all those factors referred to in those two paragraphs which I've taken you were taken into account by the judge in arriving at what was a substantial award by Trinidad standards of compensatory damages, the compensatory award itself reflected, at any rate, to some significant degree, the importance of the rights implicitly, the gravity of the breaches, and necessarily served a deterrent purpose. And I will come back to deterrence in a moment. Now, the judge's error, as I submit it, was in failing to appreciate that what she was doing in awarding this very large sum by way of compensatory damages was also to reflect, at any rate, some of the Ramanuk factors, is apparent in my submission at 235. The factors summarised by the judge in the second column of the table set out underneath 235, and which presumably were the factors that she identified as leading to the vindicatory awards in those cases, and those are awards of additional damages, all relate to the circumstances of the detention or the treatment of those claimants. And to that extent, they were just the sort of factors which the judge had already considered in the appellant's case in arriving at her compensatory award. And it's in that sense, whilst accepting, as I think I must, in response to observations that have been put to me, that gravity of the breach may connote or include other things, there is, at any rate, a very significant overlap between the compensatory award and the additional award, because the self-same factors have been taken into account.
In these cases, were the vindicatory awards the only awards made, or were there in any of them compensatory awards as well?
I'm sorry to say I don't know, but I apprehend there would have been other awards as well. I don't know. I'm sorry. I mean, that's certainly so. Well, I mean, what I can say is that in the cases of BS and SS,
The first one we see, there was a nil
vindicatory award.
So we assume there was some award.
There was an award because I was in that case.
Right.
But beyond that, I can't answer the question. But that's the overlap point. Now, it may not be a complete overlap. But if the board accepts that there is a substantial measure of overlap between, on the one hand, the factors taken into account by the judge for the purpose of arriving at the compensatory award she made, and on the other hand, the factors which the court must have regard to in considering whether it should make an additional Ramanujan-style award, then the judge has fallen into error. It wouldn't necessarily follow that there would be no entitlement to an additional award, but it would follow that the sum of $1 million was too much.
So that's the submission, is it? That vindicatory damages she was perfectly entitled to award, but the quantum was too...
No, no, my lord, forgive me if that's how I came across. I'm not saying she was... I mean, yes, she was entitled to, because there was obviously a discretion.
Right. You want her in paragraph 235 to have said, I've taken into account the amount of compensatory damages so far awarded in going on to look at vindicatory damage. That would have solved it all for you. That would then have been...
Well, she'd have had to do... Yes and no, my lord. She would have had to do a bit more than that. She would then have had to identify, as I'm about to submit, the precise basis on which she was making the additional award in those circumstances.
But if there were compensatory awards in these cases that she listed in the table, assuming that there were, that obviously there was that area of overlap in these cases, and all she's looking at, which is correct, isn't it, is the vindicatory award.
Well, she's undoubtedly looking at what is called a vindicatory award, i.e. an additional award. Now, whether there were or not compensatory awards in those cases perhaps matters not. The point I'm making is that the self-same factors as were identified in those cases as identifying, as justifying an additional award are the exact type of factors that she took into account in awarding compensatory damages.
I don't know. You're referring to the table with headed factors considered.
Which basically summarises they were mostly cases of detention, my lord. It summarises the circumstances of the detention or the treatment of those claimants. And it was those factors the judge has identified as led to the additional award in those cases.
Well, that just demonstrates...
Or in one case, certainly no.
Well, that demonstrates that those factors can justify not only compensation, but also be relevant to vindication.
Well, my lord, it might also indicate, as I submit was the case here, that there is considerable overlap, and what you can't do is compensate someone twice for the same...
But looking at paragraph 235, she seems to be doing exactly what you say she should have done, which is identify further factors. The value of the rights Joshua's entitled to, the fact that inadequacy in funding is no excuse, the public outrage and the importance of the award to deter further. Those are different factors from the age and the sexual abuse. Aren't those the fact? I mean, you may say in a different point, well, $1 million is too much, but she does seem to, although I agree that the factors considered in the cases that she lists would indicate some overlap, she is moving on from the abuse factors in 235 to identify separate...
Well, my lady, first there's the overlap point, of course, and I've made that submission. Secondly, I entirely accept that she alludes to the factors identified in Ramanujan as potentially giving rise to an additional award. What she doesn't do anywhere in her judgment, other than in that one paragraph, and this is a judgment that runs to some 100 pages, over 200 paragraphs, is explain why the compensatory award is insufficient to vindicate the appellant's rights. And although, as my lady has rightly, with respect, pointed out, she refers to those factors potentially calling for an additional award, to which Lord Nichols referred in Ramanujan, in paragraph 235 of her judgment, she does not evaluate the gravity of the breaches or the extent to which deterrence is required in any terms other than the terms she has addressed in reaching at her compensatory award. So there's...
Right, she could have spelled it out more, but we have to ask ourselves, don't we, whether the facts that she found, which she set out in considerable detail, just were capable of justifying a conclusion that requirements of sense of public outrage and so forth militated towards granting a vindicatory award.
My Lord, that may
And
be...
it's pretty hard to say that they aren't.
Well, my Lord, that may be a perfectly permissible question for the board to ask itself, and potentially a correct conclusion. But the conclusion would have, nevertheless, to take account of the very substantial overlap, which means, on any view, that the award of $1 million was reached in error, because there must be, it is clear from her reasoning and from her reliance in that table on those other cases, a very significant measure of overlap. Because, more generally, the gravity of the breaches plainly engages the gravity in terms of the harm done to the individual, and also a more objective assessment from outside, if you like, of the seriousness of the type of breach in question. Now, I've submitted that she doesn't explain her reasoning. She also makes a number of other errors in my respectful submission, which need to be put in the balance. She failed in our submission adequately to consider all the circumstances giving rise to the breaches in question. And I don't seek to labour this point particularly, but we've annexed a schedule to our case which identifies some 20 or more factual findings made by the judge which were positive from the state's perspective. And her reasoning in coming to the conclusion she does in relation to vindicatory damages doesn't allude to those at all. There is then also something to which I'll be coming, and that is that as regards the gravity of the breaches, she has presumably also factored in her conclusion that this amounted to cruel and unusual treatment, and your lordships may accept that she was right about that. The Court of Appeal took a different view. At the very least, I'm going to seek to persuade you that it's not as clear-cut as the learned judge thought it was, and demonstrate that she fell into error in certain respects in that regard, particularly in relation to her evaluation of the treatment of the appellant at St Anne's. Now, it's in all those circumstances that I respectfully submit that the Court of Appeal was entitled to come to the conclusion it did, the judge having erred for the reasons I've indicated in effectively duplicating the awards. The conclusion it came that the substantial compensatory award was sufficient. The judge ought not to have awarded the further sum of $1 million. But even if I'm wrong about that, on any view, the duplication must mean that her assessment in the sum of $1 million cannot stand.
What's the consequence of that, though?
Well, if your lordships did not accept my submission that the Court of Appeal was right and that there was no place for an additional award, but did accept that I'm right in submitting that there's clear duplication and that the judge has erred, logically the case would have to be remitted for reconsideration of the question of damages with guidance from the board. Now, my lords, can I move on now to address more briefly?
You don't say that we could come to our own view as to what the level of vindicatory damages should
Well, my lady, I hesitate to say you should definitely not, but ordinarily the board would, I think, in a case such as this, take the view, and has done in the past, that it's a matter for the local courts, who are much more familiar with local conditions, to assess the question of damages, but the board hasn't been shy of giving some guidance as to the correct approach in those circumstances. And that's actually pretty much what happened in Elaine. in fact. Now, I'm going to move, if I may, to the issue of cruel and unusual treatment now. We make the first point that, and I don't think this is challenged, that Justice of Appeal Raj Kumar was right to find that there wasn't a system, pattern of conduct or sanctioned behaviour by the state, such as to constitute deliberate acts of punishment or treatment. And I'll just give you the two references to the Court of Appeal judgment in that respect. They are paragraph 101 at 847 and 163 at 868. But I make a number of additional points. Justice of Appeal Raj Kumar was also right. Was also right in our respectful submission to conclude that the facts revealed, first, that as regards St Michael's, attempts were made to address the appellant's situation and condition, and indeed he alludes to the good faith efforts of many of the parties, both agents of the state and the hospital authority. That's paragraph 108 at 849. He further made the point that the one documented instance of an assault by a staff member at St Michael's, which was the beating with the plank of wood or the piece of wood, was not condoned by the administration, far less by the state, and triggered an investigation because the Inspector of Orphanages was appointed to investigate. As regards St Anne's, Justice of Appeal Raj Kumar draws attention to the fact that seclusion was first for limited periods, and I'll come back to that. Secondly, on occasions. And thirdly, in circumstances where his own protection or the protection of other patients or staff was required to address the circumstances of his conduct, his outbursts, and so on and so forth.
Isn't the problem really with the Court of Appeal's reasoning that it lost sight a bit of the wood for the trees and focusing on particular points like what the purpose of the seclusion was, or some people made efforts, it didn't come to anything at different times, but it lost sight of the overall fact that this child was put in and left in by the state conditions of living hell for 5 years.
Well, my lords, obviously I can't go behind the reference to living hell, and I don't seek to for a moment.
Well, if that isn't cruel and unusual, one starts to think,
well, my lord,
what do you have to do? I know it wasn't deliberate, but once you get beyond the fact that isn't a necessary condition.
My lords, I see the force of what my lord puts to me, and I don't need to take you to the authorities, but the case of Ahmad, for instance, establishes that the treatment has to reach a minimum level of severity, and so on and so forth. We may look at it in relation to seclusion. Even if your lordships are against me in the way that my lord has just put the point to me, what I will seek to persuade you at the very least is that the judge's conclusion in relation to the treatment of the appellant at St Anne's was not warranted. And that does depend upon considering the evidence in relation to seclusion somewhat and the judge's findings in relation to that.
Yes, that's a separate point.
It's a separate point.
Because you're not disputing the per diem rate for the period which is properly payable. Well, that per diem rate
we do in our written case.
In relation to St Anne's, but you don't challenge anything in relation to St Michael.
Well, we do, and I'll come to that. We say that it was over generous. What we don't challenge is the ultimate amount ordered by the Court of Appeal, but we say that the route by
I see.
awarding
Okay.
a flat rate of 450 or 750, whichever you want to take, every single day for the duration of the period was generous. So I do make
All right, I apologise.
I'll come to that later.
But it's really whether or not one characterises the breach of the right to security of person as cruel or unusual or not will be reflected in that rate.
Undoubtedly, the approach the judge took was to make a finding that there was cruel and unusual treatment and give declaratory relief in that respect, but she approached damages on the basis that the treatment that amounted to cruel and unusual treatment they were all instances of breaches of security of the person, and therefore she awarded damages to reflect that, and in the process obviously has taken account of the fact that it was cruel and unusual treatment.
Yes.
So it was a composite approach.
While you're quite correct in the case law emphasises the importance of reaching a minimum level of severity, you're not taking issue with the analogous case law in relation to Article 3, that if someone is detained by the state and the authorities fail to protect him from ill treatment by fellow cellmates or detainees, that can come within the concept of cruel and unusual
My
treatment.
Lord, I entirely accept that there's a consistent body of case law to the
Yes.
effect that actions by non-state actors is, I think, the terminology quite often used, can amount to a breach of the Article 3 right in circumstances where, to put it very simply, the state was aware of it and took no steps to do anything about it, or the state's
Failed to do anything about it.
or their conduct had permitted
Yeah.
it to take place.
Yeah.
I mean, of course I have to accept that. But my Lord, there is a serious point here, because if and you may not be, but if you are persuaded that there is force in what I'm going to say about St Anne's, then it could be, for example, that even if you're against me in relation to St Michael's and the living hell, that it was inappropriate for the judge to have made a declaratory order that there was a breach of the Section 5(2)(b) right, cruel and unusual treatment, both in respect to his placement at St Michael's and also at St Anne's. And I hope, somewhat ironically, because the judge, of course, awarded a higher
Yes.
per diem
You're trying to go not just to knock it down to the same, but to say it should have been less.
Well, I'm not going to approach it in terms of a per diem rate for present
No,
cases,
but in
I am
terms
going
of severity.
I'm going to seek to persuade you that it was actually less bad at St Anne's, and that the judge erred in that respect. Can I've just started to touch on it because I've referred to the seclusion and the observation made by the Court of Appeal that this was for limited periods, on occasions, and in circumstances for his own protection. And that is very different to solitary confinement for the purposes of punishment, to take the alternative extreme, if you like. Now, it's pertinent to note that the contemporaneous records through which we have been, and my learned junior meticulously been, refer variously to him being placed in seclusion, in a seclusion room, in a non or low stimulating environment, and in protective care. And there are, in fact, instances in the records, and there are an awful lot of records, which appear to suggest that in one or other of those respects, what actually happened was he was put in the dormitory during the daytime on his own, rather than being put in the room to which the judge referred. Now, can I just attempt, because time does not permit me to take you to all of the references, but I can certainly undertake to put in a note summarising them if that would assist after the appeal. Can I just tell you what the fruits of our detailed perusal of these huge records are in relation to seclusion? We found 28 documented instances of the appellant being placed into seclusion, and 7 instances of him being placed in what is variously described as a non-stimulating or low-stimulating environment. Now, he was at St Anne's for 371 days.
Do you mean those are over and above the 28, or...?
In addition to it, I'm sorry, lady, so that's 35 altogether. But just keeping them separate for a moment, he was at St Anne's for 371 days, so it would appear, based on the documented instances that we have been able to find, that he was placed in seclusion or protective care. Those two terms seem to be used interchangeably, approximately every 2 weeks, and then that a non or low stimulating environment was resorted to approximately every 7.5 or 8 weeks. Now that is not the regularity that one gets the impression of when one reads the judge's judgment. That's the first point. What I should say, though, is this, that contrary to the Court of Appeal's judgment, where they suggest, contradicting themselves in this respect, in one place that there was one instance where it lasted 72 hours, and in another place that there was no instance of it happening overnight, which clearly if it lasted 72 hours it must have done. We, in fact, have found 11 documented instances of him being placed in seclusion overnight. So there appears to be an error on the part of the Court of Appeal.
Are they part of the 28?
Yes.
Yes.
But as I said, there are handwritten notes that refer to him being what we think must be in the dormitory, because they refer to him lying asleep in bed during the time he was placed in a quiet or non-stimulating environment, which again would... I'm sorry, my lord.
You talk of it, just to make sure I understand what you're saying, you talk about 11 incidents out of the 28 where he was in seclusion overnight. Are you suggesting he wasn't in this little room without furniture?
I don't know, my lord.
You simply don't know.
I'm drawing it to your attention because clearly the Court of Appeal were wrong about that.
Well, he presumably wasn't in the dormitory on those occasions.
And he may not have been, because that wouldn't really make sense.
No, it wouldn't.
In the dormitory at night, he would be, where you'd expect him to be overnight. So probably on his own somewhere. Yes, I accept that. Well, I'm simply trying, having been through this in great detail.
It's very helpful because there's a danger of just having an impressionistic view.
Yes, and I mean, really what I'm saying so far is that the impression one gets is that this was something resorted to routinely, and that is not borne out by the documented instances we find. But conversely, the Court of Appeal have erred in suggesting that there was no instance of overnight seclusion. We also found only one reference to the use of 4-point restraints, or the use of restraint, in all of the contemporaneous records, and that lasted 81 minutes. Now, the judge did note, as you've been shown at paragraph 112, page 374, that there was documentation before her with a column called Nursing Instruction, Other Treatment, with comments regarding the use of restraints on 2 other dates, the 17th of January and the 4th of October.
I think we were shown that.
And you were not actually shown those, you were shown another instance.
Right.
And we found one instance, and I'm not sure whether it was the same one, but what I can say about the 2 that the judge has referred to is that we have combed through those records, and actually we can't find any documented evidence of restraint on those days. On one of the days, he was placed in seclusion. So I don't, more than that I can't make of it. Now, I'm not going to give you any more detail. I hope that is a fair summary. I'm more than happy to produce a note if the board would be assisted, summarising those findings and giving you all the page references. But
I think that would be
I
helpful.
didn't think time would permit.
Yes, we'd welcome that.
You'd welcome that. Well, of course, we'll do that. My submission, though, if I can invite your lordships to take that summary as a fair summary for present purposes, is that is not the picture that one gets from reading the judge's judgment.
Does your trawling through the documentation help us on how long the periods of seclusion were? The 28 that you've talked about.
Yes, we bear with me, my lord, if you will.
You told us 11 were overnight.
Yes, the in relation to. Yes, in relation to the, there were 24 instances where he was placed in seclusion for a recorded period of time. That's what our research revealed. And the average duration of that was 7.7 hours.
So you've got 24 instances where time is recorded.
That's what we found, my lord, yes. We will, of course, double-check what we have already done before submitting the note and make sure it's as accurate as possible. So if you find it's 25 when you get the note, please forgive me, but this is the best we've been able to do. Using the... as regards the other instances that we've looked at separately when he was placed in what's described as either a low or a non-stimulating environment, we found 4 cases where there was a recorded period of time, and that averaged 5.6 hours, so a little bit less, but not much. So broadly, for most of the instances we found of one or other type of seclusion, for want of a better general word, the range seems to have been 5.6 to 7.7 hours. Lords, we'll, of course, produce as simple as possible a note of that. There are a large number of pages of manuscript notes. They're very difficult to decipher, and the caveat that I must enter is that that's the best we were able to do, and it is possible that there is writing that we haven't been able to make sense of that also records it. But we'll do our very best to double-check it and produce a note. But my submission on that basis is that this is not a daily occurrence. This is not a very regular occurrence. It is something that was resorted to, certainly, but resorted to in those circumstances which the Court of Appeal referred to, namely for his own protection, the protection of other patients in the hospital or staff.
Is your submission then that there's no cruel and unusual treatment or punishment, or are you accepting that those would be, but they are infrequent?
No, I'm not accepting that they would be. I was going to take you, perhaps I'm doing it the wrong way around, my lady. I was going to take you to Ahmad.
We are not a fact-finding court, as you know, and I want to understand what I think, as does Lady Rose, what is the significance of our looking at these facts? Is it that you are saying that the evidence before the judge did not justify her conclusion that a major part of the plan for managing JM's needs became placement in the seclusion?
Yes, it is.
You were saying there wasn't a factual basis for that conclusion.
No sufficient basis. For
sufficient factual basis.
Yes. So that's the error, that the learned judge fell into in relation to the what I'm going to call seclusion. I was going to take you to Ahmad in this context. Ahmad, of course, is the case which I referred to a little while ago as being one of the many authorities that indicate that cruel and unusual treatment has to reach a minimum standard of severity. But it's also an important case in relation to solitary confinement or seclusion. Now, Ahmad is at tab 30 of the bundle. Which doesn't help your lordships. It's page 3508, I'm sorry.
3508.
Could I ask you to turn up page 3571? I'm not going to take you to it, but on the left-hand, at the bottom there, at 201, is the point about reaching a minimum level of severity and that being relative. Can I, though, take you to the next page, 3572, under the heading Solitary Confinement? Because the way the case is put, and the way the judge seems to have approached it, is that what the appellant is subjected to was tantamount to solitary confinement. That is something that should not be resorted to in any case, and it amounts to cruel and unusual treatment. Now, there we can see, starting, if I may, at 206, complete sensory isolation coupled with total isolation can destroy the personality and constitutes a form of inhuman treatment. 207, other forms of solitary confinement which fall short of complete sensory isolation may also violate Article 3. And just pausing there, there's evidence in the notes of him being visited and checked on. He's not just locked up. Solitary confinement is one of the most serious measures which can be imposed within a prison. Just dropping a line, all forms of solitary confinement without appropriate mental and physical stimulation are likely in the long term to have damaging effects. Then 208, at the same time, however, the court has found that prohibition of contact with other prisoners for security, disciplinary or protective reasons does not in itself amount to inhuman treatment or punishment. 209, thus, whilst prolonged removal from association with others is undesirable, whether such a measure falls within the ambit of Article 3 of the Convention depends on the particular conditions, the stringency of the measure, its duration, the objective pursued, and its effects on the person concerned. In applying these criteria, the court has never laid down precise rules governing the operation of solitary confinement. For example, it has never specified a period of time beyond which solitary confinement will attain the minimum level of severity. The court has, however, emphasised that solitary confinement, even in cases entailing relative isolation, cannot be imposed on a prisoner indefinitely. Well, I hope that's sufficient to give you the flavour of it. It's not as black and white with respect as it is suggested against us, or indeed the judge found it to be. And I do reiterate that the point's of course been made that this was an adult psychiatric hospital, and that's as may be. But it was a psychiatric hospital. He was subject to psychiatric medical supervision. And it was in that context, not in the context of prison detention, that seclusion was resorted to for, as the Court of Appeal indicated, reasons connected with his own or the safety of others. Now, I should just mention that Justice of Appeal Raj Kumar at 11F little 2, which is at 803, did hold that JM was placed in seclusion from time to time as a disciplinary measure. In fact, the judge did not make a positive factual finding that seclusion was used as a disciplinary measure anywhere in her judgment. And as I've already submitted, the contemporaneous documentary evidence that we've looked at, produced by the staff at St Anne's, does not disclose that that was the purpose of the seclusion. It was protective. That's the clear sense one gets. So those are my submissions on seclusion. Can I just give you 3 references to the Court of Appeal judgment?
Just before you do that, I think one of the factors that the first instance judge took into account was that if this had been a licensed community residence, it would have actually been contrary to the regulations.
Yes, funny enough, I was going to come to that, Lord, but can I? I'll happily deal with that. We'll deal with that now, my Lord. It's Regulation 15, as I recall, from 15B of the Community Residences Regulations. Now that is at 2364 of your bundle, and it's right that that prohibits the use of seclusion. And your Lordship is quite right that the judge found that because that prohibited the use of seclusion, it amounted to cruel and unusual treatment or punishment to resort to it. Well, first, I would submit that that's not supported by authority because it's more nuanced than that. See RMAD, as I've just taken you to. But moreover, what Regulation 15 prescribes is corporal punishment, solitary confinement, unreasonable immobilization, and unreasonable physical restraint. Now, I mean, doing the best I can, my submission is that that is clearly or most obviously aimed on a straightforward construction of it, at preventing certain types of punitive or disciplinary measure. It's not aimed at proportionate measures which may be resorted to for medical or psychiatric reasons. It can't have that in mind. It must be the former. So to the extent that the judge so suggested, with respect, she was wrong in my submission.
Now, you have in the marginal note prohibited methods of punishment.
Yes. I do. I think one gets a certain amount from the, well, what I have referred to, corporal punishment, solitary confinement. I mean, those are both words associated with punishment in my respectful submission.
But doesn't then the fact that the points that the appellant was making right at the start, that is it reasonable to draw a distinction between punishment and protection in the case of a young man whose behaviour is not because he's naughty or badly behaved, but because he suffers from this
My lady, well, we have to be a little bit careful in the absence of expert medical evidence. I mean, he had this condition. He is in a psychiatric hospital. He is subject to psychiatric oversight or supervision, and medical practitioners are therefore involved in treating him, including deciding whether or not it's appropriate for him to be put in a low-stimulating environment or subjected to seclusion for the reasons that are referred to, protective reasons. And there must be at least a presumption that even if he was in the wrong place, if I can for a moment park that, he was nevertheless treated appropriately. And certainly no basis for making a finding that medical supervision or treatment was inappropriate in the absence of expert evidence to the contrary in my submission.
I don't know whether it doesn't cut the other way, though, against your submission. I mean, if it was unlawful for the purpose of punishment, you might say, well, it's certainly not going to be permitted in circumstances that don't go as far as punishment.
But, my Lord, we're not necessarily talking about circumstances that don't go as far as punishment. We're talking about something which is qualitatively different, medical circumstances requiring treatment or in this case, the imposition of seclusion is the way I'd respond to it.
You call it medical, but it's just the fact that you can't handle the person. It's known to happen in mental hospitals that some patients get restrained, for example.
Yes, but it's known to happen, my Lord, precisely because they can pose a risk to themselves or to others. And there's a real need for the board to be careful, in my respectful submission, in speculating too much as to exactly what might have been the cause. What we know is that he was in a hospital. What we know is that he was...
But are you saying that the judge didn't have an accurate perception of what was done? Because she set out in her judgment in great detail the documented incidents.
Well, no, she set out incidents generally and in relation to St Michael's so far as
I'm looking at page 856, if we could have a look at that, in the Court of Appeal judgment, where they're saying how she carefully addressed the evidence as to seclusion, and then they quote it.
sorry, the evidence of seclusion.
Yes.
But the point I have made is that, well, perhaps I'm going behind what the Court of Appeal has said, but what I'm saying is that having looked at it, her conclusions are not borne out. The general tenor of her conclusions, and
I mean, if one looks down it, I see one of them placed in seclusion for disrespectful behaviour to staff.
yes, well, I mean,
You know, that sounds pretty disciplinary to me.
it does, and I certainly would have. I may have overlooked that in our review of the notes, but I would have drawn it to your attention if we'd found it. Is all I can say, and we will double check as we go through the notes and see whether there is any instance of that being recorded.
I'm still not
My Lord-
entirely clear, though you may be coming to this, as to what this leads to. Are you
Well,
saying that even if these incidents did amount to cruel and unusual punishment, they should have been dealt with on a incident by incident basis as far as compensation was concerned, rather than being wrapped up in...
No, my lady. All I'm on at the moment is the finding that there was cruel and unusual treatment, and the point I'm making, in the face of an obvious reluctance to accept that there was not cruel and unusual treatment, at any rate at St Michael's, where, for instance, he was burned or subjected to a beating with a piece of wood. What I am submitting is that there is not evidence properly analysed which crosses the threshold in relation to St Anne's. So in that respect, the judge...
In relation to seclusion at St Anne's.
Well, yes, and it's that the judge really...
You're saying the judge was wrong to treat it as solitary confinement?
Yes,
It didn't amount to solitary confinement.
Yes, and wrong for the reasons the Court of Appeal gave as well, to go behind the prescription of medication in the circumstances and do her own research and draw her own conclusions. He was ultimately in a psychiatric environment. And therefore our submission is that...
Well, that's part of the whole complaint, though, isn't it? That he was sent to an adult psychiatric hospital when, just because, originally, there was nowhere else they could find, and St Michael's was in a shambles. And he was treated as if he was a psychiatric patient, and an adult one at that, by people whose treatment was all geared around that.
Well,
when he wasn't one.
I accept that there is the problem that he was put in a psychiatric hospital, but it doesn't follow from that the particular treatment to which he was subjected, and that if that's the right word, in that environment, passes the threshold for cruel and unusual.
No, but I thought you were trying to draw an inference the other way around and say that because he was there in a psychiatric hospital, the sort of treatment administered was just what you would expect in a psychiatric hospital, what you might expect, and it was therefore it shouldn't be regarded as something inappropriate.
All I can say is that he was in that environment. It was supervised. The instances of seclusion were more limited than one might think, were not, on our analysis of him, for the purposes of punishment or discipline. And in those circumstances, the finding that there was a breach of the equivalent of Article 3, cruel and unusual treatment, Section 5.2b, wasn't warranted. That's the way I put it.
I mean, there's a further factor that he was subjected to medication, according to the judge in paragraph 38, was subjected to medication because of the manifestation of his syndrome, verbal and physical hostility to staff and patients.
Yes, but again, we don't, with respect, really know in the absence of medical evidence whether that was a facet of his condition which he had in any event, or a facet of being placed in the environment in which he was placed. And it is really introducing evidence or supposition from learned friends to suggest that this all flows from inappropriate detention on top of a pre-existing medical condition.
The point was made this morning, I think, that there's no evidence that there was a continuation of either administration of the type of drugs he was receiving at St Anne's or of seclusion after he left.
Yes, that point was made, and I'm not in a position to say that's wrong, my lord. What I would say is that there was a document we looked at, and my lord, Lord Hodge, pointed to the fact that it actually related to the period after he'd been moved from St Anne's and he was at the Child Support Centre.
Yeah.
And I remember that paragraph 8 of that affidavit, I think it was, identified it as being in 2018.
That's right.
It was a reference to his behaviour having deteriorated. Now, the suggestion is made, oh, that all flows from the treatment that he suffered. Now, that is a step too
Yeah,
far with
that's very
respect.
follow.
One simply can't say that necessarily. And that was, well, I can't. I'll be at risk of introducing evidence myself if I try to put it
No,
anyhow.
I think it was page 1413 was the
I think it was.
reference to the that was the that was Miss Vandana Askew Shankar Ali's statement, and in paragraph 4 she lists the forms of services that were being provided.
Yes, that's right. And then one sees that there was a marked improvement around November 2017 in paragraph 7, but then one sees in January 2018 that his behaviour began to significantly deteriorate with the frequency of tantrums and so on increasing.
Yes.
There's my lord, it was that I had in mind. I'm grateful for
Yes,
it.
I see that.
But there's a danger in one problem, of which I make no criticism, is that there wasn't any medical evidence, and that has led the judge to go further than we respectfully submit was permissible, as the Court of Appeal found. So really, just pulling it together, there are a number of matters to which I have referred, to which the judge either gave insufficient or no weight, or about which she made impermissible findings or drew impermissible inferences, and in particular in my submission, so far as the appellant's placement at St Anne's was concerned. And it's in those circumstances that we submit that even if your lordships are not persuaded that the judge was wrong in finding that there was a breach of the Section 5(2)(b) right, and that the appellant was the victim of cruel and unusual treatment at St Michael's, that the same conclusion does not necessarily follow in relation to St Anne's. And it won't surprise your lordships and my lady to hear that in those circumstances I can develop the point about the different per diem rates quite simply. In my submission, in light of what I've been saying, Justice of Appeal Raj Kumar was right to find that there wasn't a basis for the judge to have awarded a higher per diem rate at St Anne's than at St Michael's. Quite clearly, her decision to do that was influenced in large part by her appreciation of the treatment which he received at St Anne's, and her conclusion that what was actually relatively infrequent episodes of seclusion amounted to some sort of solitary confinement. Now, I do accept that the judge visited the hospital and of course had an advantage the Court of Appeal didn't, and your lordships and my lady don't have in that respect, and I can't get away from the description the judge gave of the room. I've already submitted it's not entirely clear that every instance of such seclusion was in fact in that room, but nevertheless, for all those reasons we respectfully submit that it was both wrong to find a breach of the Section 5(2)(b) right in relation to St Anne's at the very least, and wrong to differentiate or seek to differentiate in terms of daily rate. And we do also respectfully point out that as the Court of Appeal found, they enumerated the instances, the serious instances of abuse at St Michael's, which were greater in number than those at St Anne's, there being the one instance of sexual abuse at St Anne's. as compared to the 7 or 8 instances at St Michael's. So, my lords, my lady, you have, I think, forgive me one moment, I think, yes, you have, I think, my submissions, both cruel and unusual treatment and the per diem rate. Can I therefore turn to the judge's approach to, first, the period of placement at St Michael's, and secondly, her approach to damages more generally. The logical starting point is the placement at St Michael's. In that respect, I submit that the source of the magistrate's jurisdiction was Section 11 of the Children's Act, which is at 2291. Well, I'm not, in the interest of time, going to take you through all of these provisions. Can I just draw your attention to the definition at 2285 of a place of safety, constabulary station, or any hospital surgery, or any other suitable place, the occupier of which is willing temporarily to receive an infant, child, or young person. And then Section 11, which I won't read because it's lengthy, is at 2291. Can I just draw your attention to Section 11.2, and specifically, halfway down, well, a child or young person so taken to a place of safety, and also any child or young person who seeks refuge in a place of safety, may there be detained until he can be brought before a magistrate, and such magistrate may make such order as is mentioned in the next following subsection, and that's subsection 3, which refers to specific types of order, or, and these are the words I underline, may cause the child or young person to be dealt with as circumstances may admit and require. Now that's the more general jurisdiction under which the magistrate was, as the Court of Appeal found, entitled to proceed. Now, I've taken you to the definition of place of safety. We know from the evidence within the record, and you were shown it, I think, that it's the record of the proceedings in the magistrate's court, that we know that he was taken first to Siparia police station by police constable Ram Clackwan and woman police constable Darlene Wren Lashley. That's at 972 to 3, and also at 1980 and 1983. When his mother first appeared at the magistrate's court a day later, on the 18th of September, the notes in the court file state, at present, children with Ferndean Children's Home, and give an address, remanded in custody for safekeeping. Now, can I just briefly deal with one point that was made about the language that was used by the magistrate? This is not something, contrary to my learned friend's invitation, that ought to concern the board, in my respectful submission. The Court of Appeal at paragraph 28 on page 813 said this: in the notes on the fly sheet, it was recorded JM was remanded for safekeeping at St Michael's. On the latter date, it's recorded urgent report. It's clear that despite the brevity of the note and the use of the term remanded on occasion, but the magistrate intended to exercise the jurisdiction for placement of a child victim, and nothing more sinister need to be read into the use of that term, such as that he was mistakenly being treated as a child offender. See also example notes, and there are various dates, and then the court emphasises virtual complainant remanded in custody. The remanding in custody of a virtual complainant could not make sense unless it were, in fact, the remanding for safekeeping referred to earlier in the note. So it was a shorthand. was being used by the magistrate. She was placing him as the virtual
Placing him involuntarily in a way, in that sense.
Well,
It is remand, yes, that he has to go there. It's not his choice, his little
No,
child.
but he was a child,
Yes,
my lady,
yes.
and
So in
the
that
court
sense,
had to do what it could.
it is remanding him, but for a different reason from the usual reason we associate with that word. Is that fair?
He was being, has different connotations, this word, so perhaps the wrong word. He was committed to the state's care, and that was the language she used. Can I just make these submissions in relation to Ferndean and the police station? There's no suggestion that Ferndean Children's Home was not a place of safety, and similarly, the police station self-evidently counted as such a place. And it was therefore open to the magistrate to exercise the discretion available under section 11.2 of the old Act that I've shown you, as circumstances may admit and require. Now,
What does that mean?
it's a very wide discretion. Does
Does it include sending someone to a place that is not a place of safety and is not suitable for their detention?
Well, she had to do the best in the interests of the child that was achievable, is I suppose.
But that may involve breaking the law.
Well, it doesn't involve breaking the law if it's a valid exercise of her discretion in sending him to or placing him.
Well, I mean, just because there isn't an appropriate place available doesn't mean that if you send somebody somewhere else, that's...
But the evidence is clear that although there were other homes, Ferndean was one, he was sent there. They weren't able to deal with him, and they refused to take him, and the magistrate was driven to placing him at St Michael's as the only place prepared to take him or able to take him. That's the evidence, my lord.
Well, I know that's the evidence, but one interpretation of the evidence is that the magistrate was driven to doing something unlawful because there wasn't a way of complying with the law.
Well, no. If Section 11.2 had prescribed, as Section 12.7 does effectively, that he must, in those circumstances, having been taken to a place of safety and then brought before the magistrate, be placed in an orphanage, she would have broken the law in placing him at St Michael's, but it doesn't. It contains those words about which my Lord Hodge just asked me, as circumstances may admit and require. So our submission is that it wasn't unlawful. She was doing the best she could, as circumstances admitted and required. She was doing the very best she could. So it wasn't unlawful. Now,
Well, the question is whether those words are wide enough to permit the magistrate to send JM to an institution which exists for a specific statutory purpose, namely the detention of offenders aged between 10 and, I think it's 16.
my Lord, I
mean, that's the point of construction of the provision, isn't it?
Well,
I mean, supposing the only place available had been an adult prison, would that have been intra vires?
Well, my Lord, the magistrate was in a position where she was compelled to make a decision about the placement of the child in the child's interest.
Yeah.
The section requires her, in effect, to do the best she can in the circumstances for
So
the
that
child.
could include an adult prison.
Well, it could. I mean, the case of BS and SS was a case in which, well, I mean, it's reported with its full name, so there's no harm in me saying it. Sasha Sipasad was actually detained in an adult prison, but she was
Under this provision?
no, she was a person who was charged with murder and awaiting trial, but she was a juvenile.
This is CPSAD. Yes.
So I don't.
Yes, well, it's a rather different thing.
It is a different.
This provision is a sort of emergency provision. If this child is found in the street, or if the child is in the care of the parent and the parent is now in custody for mistreating the child or something else. So this is dealing with an emergency. And then there's a later provision for what you do when the emergency is over, and there may be more time to consider other options.
Well, My lady, it certainly in the first instance is what can be done with the child who's either found himself before the magistrate for the reason this child did, or for some other reason, wandering the street or vagrancy or whatever it might be. But what is absolutely clear from section 11.3 is that it is not until after the conviction of the person with emotional care, the mother, and indeed 21 days after that, that a different type of order has to be made. And that's when you get into section 12.
Just one last point on section 11.2. It can't be a correct construction, can it? I think Lord Hodge was really making this point, that the place to which the magistrate makes the order is not a place of safety, that the child, having had to be removed to a place of safety, can then be ordered to go somewhere which is not a place of safety. That couldn't be correct.
No, but the magistrate has to ask herself whether the place which she is considering the child to is capable of looking after the child. And if the magistrate makes the decision that that is the case, that is a lawful order. If it transpires that it's not safe because of abuse meted out by older residents or even staff members, then that's a separate question in my respect.
Well, I wonder about that. I mean sending a vulnerable child aged 9 to an institution for young offenders of a greater age, and there might be at least a prima facie case that the very nature of the institution meant it wasn't a place of safety. I mean, the point I'm making here, I think, is this, that the assumption in 11.2 and 11.3 is that, in 11.2, for example, is that if the initial place of safety where the child has sought refuge isn't available, then the magistrate is expected to find another place of safety. And similarly, under 11.3, pending the charge and conviction, then the place has to be, the order has to be as circumstances require for the care and detention of the child. Again, the underlying assumption is that it will be a place of safety. And as in the CPSAD case, where a judge was forced to make orders which were not compliant with the law because of the lack of facilities, that was held to be a failure to give the child the protection of the law. Why does that not apply equally here?
Well, my Lord, as my Lords Leggett and Burrows will remember from CPSAD, there is the distinction that there were two mandatory provisions, sections 54 and 60, in play in CPSAD that specifically required the children to be put in a community residence.
Yes, but here, I mean, the substrate of these provisions is that the child will be sent to a place of safety.
But my Lords, with respect, coming back to something your Lordship was saying a moment ago about the nature of the institution, that really involves proceeding on the presupposition that it could not be a place of safety to send a child to. It is an institution for offenders, but it does include children, St Michael's. It doesn't follow, as night follows day, that such a place would be incapable of taking care of the child. And the magistrate found herself, and in this sense there was a similarity with CPSAD, perhaps between a rock and a hard place, and she had to do the best she could. But my submission is that on the wording, and at any rate my construction of 11.2, it was not an unlawful order. I do accept, as the Court of Appeal found, that after 21 days had lapsed following the conviction of his mother in 2014, then there was a requirement to proceed under different provisions, and he should have been placed in an orphanage at that point. I do accept that. Now, I'm sorry, my Lords,
Would that be a Section 12 order at that point?
Yes, 12.7, I think, in the absence of being able to place him with a relative or anyone else appropriate. It would have to be resort to section 12.7.
Do you agree with the inference suggested this morning from the court record, I think, that the magistrate called for a suitability report at one stage, never got it, and just went ahead and sent him off to St Michael's anyway?
Well, it would appear that the suitability report wasn't received. Yes, I accept that. But there were a number of points made this morning that with respect to aren't warranted. So one of them was that he was never produced to the court. But with respect, that was not a criticism made in either of the courts below, and it's not something in relation to which the board has any findings. And there's no... There's a danger of reading a little too much into some of the evidence which you were shown this morning. I mean, the Court of Appeal made the point that the evidence in this case was all written. There was no cross-examination, and I'm not going to take your lordships to it, but I mean, I could show you an affidavit which contradicted what the mother said, which you were shown about, the instances of abuse and so on. And the state put in an affidavit which made the point that she wasn't in a position to know that. She didn't attend regularly. It was all hearsay, and it wasn't the case that he was abused in the way that... But these are
fact. It may or may not coincide with her affidavit, but that's
right,
weird.
my lady. I mean, so obviously documentary evidence is there, and some of it speaks for itself, but there is a danger in reading too much into it. And the judge did set out everything that he said under the heading evidence, not findings of fact, and that's precisely the difficulty with this sort of case. But I don't want to push that too far. I just so you're aware. Now, my lords, can I? Would your lordships give me just 1 moment? Yes, so my lords and my lady have my submission as regards the initial placement at St Michael's, at any rate up until the conviction of his mother. The next thing that I'll address, if I may, briefly, I don't think this point is persisted in, but there was no breach of due process in my submission in relation to the placement at St Michael's, and that's for the reasons that we've set out in our printed case, and I won't seek to elaborate on those. They follow the CPSAD reasons. There was recourse to the court and so on and so forth. So can I just turn to protection of the law next? As regards that, the Court of Appeal in our submission was justified in finding that there was no breach before the majority of the provisions of the New Children Act were brought into force on the 18th of May. I say that because we seek to distinguish this case from CPSAD. I've already alluded to the fact that in CPSAD there were mandatory provisions requiring placement in a particular environment after the inception of the New Children Act on the 18th of May 2015. And we see that in paragraphs 65 and 68. Can I just give you the reference to CPSAD? It's 3009. I'm not going to take you to them. Unlike CPSAD, in this case, subject to the debate we've been having about Section 11(2) and the requirement of the court on a proper construction of that section, I submit that there were no equivalent mandatory provisions before the conviction of the appellant's mother. Rather, the magistrate had a discretion which she exercised having regard to the availability of homes to accommodate the appellant. And in those circumstances, at any rate up until that date, 21 days after conviction of the mother... I
think we've gone on to the New Children Act point now.
No,
You're accepting a parallel, are you, between the orphanage and the Children Act situation, but not between the pre-conviction and
I'm
the...
submitting because of the distinctions which are between, on the one hand, this case and CPSAD. The Court of Appeal was justified to reach the conclusion it did. I can see that there might be a stronger argument in relation to the period after the 10th of June, when there was a requirement for him to be sent to an orphanage. But my lord, I'm not conceding that it...
You're not conceding it, but Section 12 seems to suggest it's you either find a suitable relative or you go to an orphanage.
It does, I accept that.
You're making no concession in the earlier period because you're not accepting the suggestion that's come from the board, at least some of the board, that that built into Section 11, 2 and 3 is the presumption that the magistrate's power relates to the finding of a place that is safe.
Well, my lord, I've found myself arguing a somewhat different proposition as to the discretion of the magistrate to the construction put to me by the board. So no, I'm not conceding that. What I do accept is that there is a factual change on the 10th of June 2014, but I don't concede, because one can distinguish CPSAD on a more general basis, namely the Court of Appeal attached importance to the fact that the bringing into force of the provisions of the new Children Act on the 15th of May 2015, 18th of May, forgive me, 2015, brought with it a new regime and the requirement for the appellant to be placed in a community residence. But more than that, I can't say.
Where does this all lead to in terms of the effect of these submissions? Because have you dealt with the point, maybe you have and I've missed it, that put against you is, well, whatever you say about breach of protection of the law, there was a breach of the security of the person.
Just coming.
You're coming to that, okay.
No, I'm very...
You're conscious of the passage of time. Yes. I'll let you get on.
You've asked a lot of questions, my lord, and I'm sorry that I'm not quite making as much progress as I would.
No, please proceed, but promptly.
Can I try and deal with it in this way? Even if the Court of Appeal erred in respect to the protection of the law, which I've just been on, or, taking my Lord Borough's point, as the appellant suggests, by failing to compensate the appellant for breach of his right to security of the person between September 2012 and 18th of May 2015, I respectfully submit that there is nevertheless no basis for challenging the Court of Appeal's order in respect of damages, which was, we submit, sufficient to vindicate the appellant's rights. Now, to make that good, can I first say something about these overlapping rights?
You mean sufficient to compensate?
I mean in the constitutional sense, which includes all forms of damages, my lord. I'm sorry,
Yes.
I'm probably...
Sufficient to compensate, which you say is sufficient vindication.
Sufficient redress under Section 14. Yes. I should have made myself clearer. Thank you, my lord.
Yes.
Can I make this point first? The separate rights to security of the person and protection of the law were entirely coextensive in my submission. So assuming for present purposes that there were breaches of both, contrary to the Court of Appeal's approach, it was either a case of breaches of the right to security of the person resulting in a failure in the protection of the law, or the opposite. The judge herself clearly considered the rights to be coterminous, and we see that from paragraph 158 of her judgment, which is at 388.
Well, I think you better, given the time, you better just leave us with references, because we must make progress.
It is 388. Similarly, the Court of Appeal recognised at paragraph 162, which you've been shown, which is 867, that breach of the protection of the law after the 18th of May exposed the appellant to harm, albeit the Court of Appeal in fact saw fit to award separate additional awards for specific instances of assault. Now, my lords, can I then just... I'm going to take this as quickly as I can. If you just give me one moment, it may make it easier for me to take it quickly. Can I do this by reference to my printed case? I wasn't going to do it this way.
Yes, of course you can.
2269, please.
We will take account of anything in your printed case from which you haven't
Well,
expressly
I know
departed.
you will, but what I'm going to address you on, my lords, are the really important parts, if I may. Paragraph 40B, the flat rate of $450 per day was over-generous, we submit. And then we've referred to how the judge got to it, and I won't read that at little 1, by reference to the case of Dillon. Little 2 develops that, and it was as a result of being taken to that case that she arrived at the rate of 450. Then at little 3 on 2270, we say first that the judge impermissibly took account of the fact that he was being housed at a place contrary to the law from the age of 9. Now that depends on what my lord and my lady make of the section 11.1 argument. But we then make an important point in subsection 4. There was reference below to the case of Thompson, which was a case of false imprisonment. That case included guidance which was given by Lord Wolfe as to how to approach damages in the case of false imprisonment, and suggested that there should be a sliding scale. Now, whilst I accept entirely that the guidance was given in relation to common law claims for false imprisonment, and that different considerations may apply to constitutional redress, there is, I submit, no reason in principle why, by analogy, a reducing scale, as was recommended in Thompson, the reference to which you've got in little 4, should not be adopted in the approach to damages.
But was there any question in Thompson of the security of the person, of the prisoner? Yeah, well, that's...
The reasoning is the sort of clang of the prison door thing, that one day in prison is terrible, but after a year it sort of wears off. But that doesn't really apply here.
Well, no, but I was careful to say by analogy, my lord. The point in Thompson was that the initial hour or period, whatever you want to call it, detention is the immediate shock, and it's that attracts the higher level of damages. But thereafter, whatever length the period is, one should apply a reducing scale. Now, by analogy, whilst I entirely accept, I hope I've already fairly accepted that different considerations may apply in a constitutional case, it is not the case that on each and every day of this very long period, the appellant was subjected to instances of severe abuse or assault or seclusion, depending on makes of seclusion. There were such instances, and I accept that the Court of Appeal found that he was in fear throughout that period, or would have been in fear throughout that period, but qualitatively it is not the case that each and every day carried with it the same harm or threat of harm. And no such reducing scale was obviously applied in this case. What I ought to just tell your lordships, because it's not, and my lady, because it's not in our printed case, is that the reducing scale approach was endorsed by the board in Takitota, which was a case from the Bahamas, but I accept a common law case of the same type as Thompson. That's at paragraph 10 at 3277 and paragraph 18 at 3280. So, pulling this together, if I can, in just literally a couple of minutes before I sit down, the Court of Appeal, well, perhaps I can take it this way. If the Court of Appeal erred in its approach to compensating JM for the reasons that have been ventilated in relation to security of the person and the period for which he was perhaps not compensated for that, and or protection of the law, then any risk of undercompensation in the amount they arrived at of over £800,000 was mitigated by 3 factors. First, that the judge, we say, wrongly allowed for illegality for the first 2 years of detention. That's the 11.1 point. Secondly, the fact that the Court of Appeal allowed separate additional sums, which the judge did not, for specific instances of breach of security of person. And finally, because it was in any event an overgenerous award, because not a flat rate, but a reducing or tapering rate ought to have been adopted. And it's in those circumstances, if you accept our submissions in relation to the absence of any requirement for an additional award, the £1 million, that we submit that in all the circumstances the amount ordered was sufficient. But as I submitted earlier, if you're not entirely with me in relation to vindicatory damages, then at the very least, because of the fact that the judge fell into the trap of, because of the overlap point, that amount was clearly too much. My Lords, I'm sorry I've taken longer than my allotted time.
Well, you faced a lot of questions.
I faced a few questions, perfectly fair questions.
Thank you. Mr. Ramlogan.
My Lord, my Lord, I'm conscious that we've overstepped. I'll be brief. My Lord, can I take you to page 2271 in my learned friend's, Mr. Stevens' case for the respondent, 2271, paragraph 41. Paragraph 41, where my learned friend says that his arguments are proceeded on the basis that it was inappropriate to apply the flat daily rate. However, the respondent has not sought to appeal that aspect of the Court of Appeal's judgment because it does not challenge or seek to vary the overall damages awarded. Nevertheless, if contrary, it's suggested that it is necessary to cross-appeal at this point. They reserve the right to do so. I mean, there's been no application to cross-appeal on the point. And
was it argued in the Court of Appeal that it was wrong for the judge to award a flat per day rate and it ought to have been a sliding scale? Was that one of the arguments made to the Court of Appeal by the respondent?
I don't was that? My Lord, I don't recall that being an argument before the Court of Appeal.
I know there was reference to Thompson, but whether there was that argument.
Well, I did the matter in the Court of Appeal. I don't think that was raised by the state, my Lord. But
well, if it was, we could be told that that's wrong afterwards, perhaps.
Sure. My Lord, might I quickly take you to page 1008? To make a simple point, this report at 1008 is dated the 5th of May 2017, and as you can see from the first line, the minor would have been sent to St. Anne's on the 6th of October 2016. So the report is 7 months into his stay at St. Anne's. And what I found interesting is if I take you to the second to last paragraph, it says he's been administered oral medication, behavioral modification techniques. He's been placed in the seclusion room on numerous occasions for the aforementioned behavior. Now that's 7 months into the stay, and the child would have had a further 7 months. Now, the use of the word numerous occasions for the aforementioned behavior, I take note on it because the itemization of the number of instances that are recorded in the actual notes may not actually give an accurate picture just as well. And then the court, and it's clear as well that as the Court of Appeal found, this was used as a disciplinary measure. Now, my Lord, I shan't spend too long on the case of CPSAD, but CPSAD, the board found that to put the judicial officer in a position where they were not able to implement and comply with the law by not having a place available for the judicial officer to place and house the minor was in itself a breach of the right to protection of the law. And that is precisely the case here, where the place prescribed and contemplated by law was not was not available, and hence the court had to act in breach of the law.
So you are in effect adopting the suggestion that 11(2) and 3, implicit in that was that there had to be a place which was safe.
Yes.
For the magistrate to place the child.
Indeed.
Yes, and if that is correct, then supersad is analogous.
Indeed, correct. Thank you, my lord. And then I take you quickly to page 3040. The judgment in Mercy and Cartwright at letter D, the sum appropriate to be awarded to achieve that purpose would depend on the nature of the infringement circumstances, and it would be a sum at the discretion of the trial judge. In the instant case, an award of damages to vindicate the appellant's rights that had been so grievously infringed were clearly justified, etc. There was a wholesale contempt shown by the authorities to the rule of law, and the requirements made in the instant case was a proper one for the award of vindicatory damages. In this case, they awarded compensatory damages with an element of aggravation, but yet still they went on to award vindicatory damages, and it was a case, it wasn't actually a constitutional case. It was a case for damages for assault, battery, false imprisonment, and malicious prosecution. So it's an unusual case where vindicatory damages were nevertheless upheld by the board in the context of a tortious claim. And then if I can quickly go to 3048. So, 3048. At 3048 letter F, the purpose of the vindicatory award is not punitive. It's not to teach the executive to misbehave. It's to vindicate the right of the complainant, the unjustified executive interference, and so on. There's some appropriate to be awarded to achieve this purpose will depend on the nature of the particular infringement, circumstances, in the discretion of the trial judge. In some cases, a suitable declaration may suffice. Other cases, an award, including substantial damages, may seem necessary. In the present case, leaving aside the moment of duplication, the substantial award was justified. So the point is, you can have, the law contemplates, you can have a substantial award as vindicatory damages in an appropriate case, and we say this is an entirely exceptional case that justified such an award. As my learned friend made reference to the sliding scale, we say that that principle ought to be viewed with some degree of circumspection in the case of a child. It would be wrong. It would be wrong in my respect for me to assume that the child would grow comfortably accustomed to such conditions as time goes on. It may very well be quite the opposite, where the anguish and the stress on the child would actually intensify and become worse as time goes on.
Well, in any event, the Thompson principle doesn't apply where a child is in constant fear of being abused, it seems to me.
Indeed, my lord. Indeed. And can I finally take you to page 1427? At paragraph 16. Joshua displayed unacceptable forms of behavior, and they said attempts at counseling were not always successful. When this failed, there was no option left but to place him in a seclusion room at St. Anne's, and the policies to give him the medication, intramuscular, and so on. The point is, in the notes, I've not been able to find any successful attempt at counseling noted, and there is no notation of when counseling failed, such as to justify him being placed in the seclusion room either. And I just thought it's interesting to note. Yes, and this is, in fact, paragraph 16, described as a major part of the treatment plan for Joshua, for the minor when he's there. So it's a major plank of the treatment plan. Can I just, two quick references. And two quick references at page 69. Sorry, 869, beg your pardon, 869. Yeah, at 869, this is in the Court of Appeals judgment. We'd mentioned it, and I just wanted to give you the reference. 869, paragraph 166, you'll see the Court of Appeals said his mother was not cooperative in taking him back in an apartment at St. Anne's. Her role and responsibility was ignored by the trial judge. We've already made submissions as to the fact that they ought not to have taken that into account in relation to the case brought by the minor, and that's one instance where the conduct of the mother was taken into account. The judge was quite frankly correct to ignore it. And then I go to 845. At 845, paragraph 90, again, they said, the mother's role in this situation cannot be ignored. She was only prepared to take him back for brief periods, yet she complains that the home did not continue the interventions that were recommended for him after a year had passed. We said that's irrelevant, and we don't see why. We think that the trial judge was correct to at least look upon the mother favorably for at least seeking the child's welfare to bring this claim. And this is the undercurrent of subconscious influence that we spoke about as that crept into the judgment that we didn't think justified. And finally, in Takitoto, the court discussed the aggravating factors that would find its way into the award for compensatory damages, but nevertheless, in a distinct and separate award, awarded vindicatory damages, which reinforces the point that the concept of vindicatory damages is separate and apart from the compensatory damages, which can in fact include an element of aggravation. But it does not mean that that precludes the award of vindicatory damages. My lords, unless there's any further, those are my submissions. We've made up for some lost time.
Mr. Amlogan, thank you very much. Well, the board is very grateful to counsel for their careful submissions, and grateful also, very grateful also to those who have assisted counsel in the preparation of their cases. This has been a obviously difficult and distressing case for all parties, having regard to the circumstances of the child, and the board will take time to consider their judgment. The board will now adjourn.